Thank you for joining us on Bees on the Law, legal talk from the boss perspective. This podcast is for informational purposes only and is not intended to provide legal advice and is not meant to create an attorney-client relationship. Also remember, laws change and differ from state to state, so this is not a substitute for seeking legal advice in your jurisdiction on the current law applicable to you. Hi, everybody. Welcome to this very special Illinois edition of Bees on the Law. As most of you know by now, I'm from California, and Illinois, Susan always says, wants to be California. So today we're going to talk about some of the new laws that have been passed specific to Illinois. And my favorite one, Susan, I'm not going to lie, after reading our outline, my favorite one has to be the fact that Illinois felt the need to pass a law specific that does not allow video conferencing while you're driving. Like, I don't know why. I find that is kind of common sense, but yet apparently it was happening, so they needed to pass a law about it.
I suppose.
I was distracted driving myself. But.
Right. Why not throw one more law out there, right? I mean, come on. It's not as if the current law on the book didn't already prevent this from happening. But let's get specific and say you cannot video conference while you are driving a car. I mean, I don't understand it. If you can't hold a cell phone, how could you be video conferencing? But yes, that is a newer one that does give you kind of a little chuckle of thinking, what are we doing? But we do have quite a few new laws here, and many of them, other than the video conferencing, what happens? Everyone needs to update their policy in their handbook that says no distracted driving, which if you don't have a no distracted driving policy in your handbook, get one. And if you do, you need to make sure that you specifically talk about video conferencing. I mean,
in all seriousness, you do have to plan for some of these. And there's actually some really interesting laws that need to be planned for in Illinois, it looks like.
Right. One of them is the new Transportation Benefits Program Act. It's very, very specific who this applies to. And you have to be you have to have 50 or more employees, and you have to be within, I think it's a mile, I'd have to find it, of the CTA or some sort of public transport. But so it doesn't apply to everyone. But if it does apply, you have to allow your employees to have use pre-tax dollars to buy their Metro card, their CTA card, whatever public transport they're using. So that one is an interesting one. The only thing that it does to impact employers is if you don't have some sort of cafeteria plan available already, where you're allowing people to use pre-tax dollars for medical or for daycare, you have to set that up. But again, it only applies to over 50 employers, and it's very specific. You have to be located in a very specific area for that to apply to you. There's a couple other lesser known laws that are coming out that are very similar. We have the Victims Economic Security and Safety Act, which a lot of states have. And that, of course, applies to all employers, but does provide leave dependence upon how many employees you have. And then we also have the Illinois Child Bereavement Leave Act, or there's the Family Bereavement Leave Act, that has been updated to have the Illinois Child Extended Bereavement Leave. That one applies to only 50 employers and over, but both of them are dealing with what happens if child or a loved one is impacted by a violent crime or suicide. And it gives additional leave time to those individuals for that specific instance. So they're addressing, obviously, there's, everyone listens to the news. There's been a lot of violence here in Chicago and in the Chicagoland area, I should say. And these laws are intended to allow people to have more time to grieve and address in those violent crime situations. So
yeah, it would be my hope that this is never needed, but I know unfortunately it's the reality for families.
It is the reality for some families. It doesn't come up as much. It's one of those things that when clients call me and asking about different laws, I don't really get too many people saying, tell me about VESA, right? The Victims Economic Safety and Security Act. But these things do come up. So it's important to be aware of them, to know that they're there, especially if someone came to you for bereavement leave and, you're a small employer, you have 5 employees, and you didn't realize that because their child committed suicide, and you're like, well, I know I don't have to do bereavement leave because I don't have 50 employees. Well, there is this VESA, and it's there. So just be aware of it. Know that you have those obligations. So then we have there's a couple other things going on that are really interesting. There's tons going on. I'm not going to touch all of it. I mean, there's the amendment to the Gender Violence Act. That's, a minor, not minor. Whoa. I mean, if this applies to you, it is important. I don't mean it that way, but it's a change in the terminology. That's what I mean by a minor change. We've got the amendment to the Personnel Record Review Act. So if an employee says to you, hey, I want a copy of my file, the old act said you could come to the office and look at it. Now the employee has the right to say, email it to me. Well, I don't really know too many businesses that weren't already emailing these out, but it is now the law that if the employee asks, you have to email it. We've got amendments to the Blood and Organ Donation Act, giving more leave for people that are donating organs, giving blood, those kind of things. The biggest acts that are hitting the state are the paid leave acts. We have 2 big ones. We have the Illinois Paid Leave for All Workers Act, and that is the paid leave up to 5 days for any reason or no reason at all. And it's very specific, and the state has not even issued its guidance yet. The guidance is due by March. The law goes into place in January. The state has had wonderful webinars that are still going on. Will be going on in January. If anyone has questions, they don't answer every question, and there still are very complex questions that need to be answered. We're doing the best we can, but it is for all employees, part-time, full-time, seasonal, and they have the right to either accrue or you can front load paid leave 1 hour for every 40 hours worked if you're doing an accrual process, up to 5 days leave. It's very specific. You can't ask why. If you're going to set a rule that says that we can deny your request, you have to be specific and advise the client or the employees when you're going to. You can't just say due to seasonal demands. You have to say during these weeks, our peak season, you cannot, or if so many employees have already requested, you cannot, right? You have to be very specific.
Oh, interesting.
Yeah, very specific. You cannot be general. You have to explain. The employees need to be on notice of when they could potentially get denied. And that's not clear if you just read the act. That's not clear. That comes out of the webinars that I've been attending. Yes. So it's interesting because they only have to give 7 days notice. And for a lot of businesses, especially small businesses, 7 days notice of someone being out for a day or two, if they're going to take it in those kind of larger blocks, can be difficult to address. But the employees can take it in small increments of 2 hours. What I'm finding is that a lot of employers think, well, I already provide 40 hours or more. I provide more, so I don't need to change my handbook. Well, that's not true, because you have to allow for 40 hours for any reason. So if you have a PTO policy that says you can take leave for these 10 reasons, you violate the law. And some employers have policies that say doctor's appointments must be made on the weekend. Well, no, not anymore. So you need to make sure that your policy follows the law for at least those 40 hours. A lot of employers don't want to go back to the 2-bucket system where you have paid leave and vacation, or paid leave and sick, or something like that. But many are going back to that 2-bucket system. A big reason why is that this leave does not have to be paid out on separation. So if it's not used and someone quits, you don't have to pay them for the unused time.
Oh, right. But you have to pay out.
Right. But you have to pay out the other leave. So if you were giving 80 hours of PTO and you cut it back and you do 5 hours of paid leave and 5 hours of PTO, now you've created 40 hours. You've created a bucket of leave that doesn't have to be paid out in separation. And if you lump it all together, it does have to be paid out, and you also have to follow those 2-hour increments and 7 days notice and all of those requirements. So for many employers, it makes more sense to have the 2-bucket system, or 3 buckets if you're going to do vacation, paid leave, and sick.
Oh, that's interesting.
Yeah.
And I bet a lot of I wonder how many employers are going to go to kind of a more 3-bucket system. Because to me, that seems a little more complicated, quite frankly.
Well, it seems like it's complicated unless you're using kind of an online payroll company or
Right.
some sort of outsourced payroll company, where if you go online to request the time off, you have to say which bucket you're pulling from, right? And so the
Right.
employee is it's just accruing per paycheck, and the employee is making the request. So it can seem like it's very complicated. If you're trying to do it in-house, it probably would be, but there are plenty of payroll systems that are very set up for this, and can make it very simple for employers if they want to maintain those multiple buckets. But it's really up to the business, what works best for you. But along those lines, the Chicago, and I know in our new laws around the country, I touched base briefly about the Chicago paid leave and paid sick and safe leave. So Chicago did not want to be left out, since Illinois has this new paid leave act. And Chicago already had a paid sick leave ordinance. They decided that, nope, 5 days isn't enough. Now everyone should get up to 10. That went into effect on November 9th. And then just early December, they went, oh, wait, whoops, never mind. We're going to hold. So currently, that law is on hold and is supposed to go into effect on July 1st. But in addition to putting it on hold, they also made changes to the ordinance, which leads me to believe more changes might be coming. So we should pay attention to that. Just keep an eye on it. Know that it's coming. It's coming at some point. We just don't know what that final draft will look like. And we don't know if it'll go into effect in July, or will they push it off more? We don't know. But right now it's July, and employees would get up to 5 days paid leave and up to 5 days paid sick at different accrual rates than the state. So it accrues faster than the state, and it's just very different. If there's any good news, the state law does say if you fall under the Chicago ordinance, you don't have to follow the state law, because they say you're already complying with the Chicago. So if you're in Chicago, you're okay right now. We just need to just keep an eye on this act. But that's another big one. The last one that is really interesting, and I'm going to see that I want to talk about briefly, that I'm going to really see how this goes, is the Chicago's one fair wage ordinance, which is increasing the hourly wage for tipped workers to get them up to minimum wage. And so the question is, does that eliminate tipping in Chicago, right? If people are, because, the going from paying someone at that reduced hourly rate to the minimum wage in Chicago, is who's gonna eat that cost? Not the restaurant owner, right? Not the bar. They're gonna increase prices. And so you're already paying more for your food and what have you. Is that going to result in people saying, well, then I guess I don't have to tip?
So it'll be interesting. We have a few, in LA, as you know, we have different and higher minimum wages in the city than the rest of the state. And one of the things a few of the restaurants around us have done is there's kind of a mandatory tip just added to your bill, and there's no room to tip anymore. It's just added in automatically.
Interesting.
And as well as a healthcare fee, I guess, to some of them as well, that we're seeing. But there's no tip. It's kind of auto added for you, and you're going to pay 18 or 20% extra on top of the meal for those services, but then there's no tip. And I personally like that better, because I know how much the meal is going to cost me when I'm ordering.
Right.
Yeah.
As a former server, I like to be able to tip, because I over tip if service is good. I also question, many people in bars and restaurants are making well above $15 an hour right now, or whatever the minimum wage is in Chicago these days. They're making well above it. You eliminate tipping, or people say, I don't have to tip 20%. Maybe I'll give you 5 or 10. How is that going to impact their livelihood? And that is really the big question that a lot of conversation has been had around that. Is it going to impact how much some of these people are making. I'm sure that's not everywhere. It's not everywhere in Chicago,
Right.
but in the touristy areas, in the Loop, in the kind of those areas,
Mhm.
is that going to impact? So we'll see. We'll see how it goes. But lots and lots of stuff going into effect here in Illinois, and we have more coming in July, and we'll be touching on that later.
All right, everybody. Thank you so much for joining us on this special Illinois edition of Bees on the Law. Thank you for joining us on today's podcast of Bees on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at beesonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.